Hello, and welcome to Women Speak, a production of the Women's Resource Center in Wayne. I'm your host, Mojdeh Keykhah, and each month I will be focusing on a topic that will interest women and the people they care for. This interview is being conducted via Zoom during the coronavirus crisis 2020, a very challenging time. Today, Women Speak is happy to have with us attorney Jennifer J. Riley. Hello. Jennifer is the founder and managing attorney of the law office of Jennifer J. Riley with offices in Bluebell and Wayne. She earned her MA and her bachelor's from Villanova University and her JD from Temple University. Ms. Riley has been named one of Pennsylvania's super lawyers' rising stars by a poll of her peers during the years 2012 through 2020. She and her associate attorneys practice family law and estate planning in Montgomery County, Chester County, Delaware County, and Bucks County. She has appeared as a guest attorney on It's Your Call with Lynn Doyle and has co-hosted a local radio show related to the law and the local community. Ms. Riley is a volunteer attorney with the Women's Resource Center and the Montgomery County Child Advocacy Project. She and I will be discussing family law, which includes divorce and custody issues with the special circumstances brought on by the coronavirus crisis. Jennifer, I am excited and honored that you are joining Women Speak today.
It's my honor to be here. Thank you for asking me to join you.
Thank you. And I would like to jump right in with our first question. How did you get involved in the work that you do today?
So family law in particular, I did not actually intend to be a family law attorney. I went to graduate school for international human rights and intended to work more in the NGO community. When I graduated law school, I ended up at a wonderful firm in Montgomery County, Pennsylvania, and they needed assistance in the family law division. So I started to work in family law. I worked in different areas at that firm, but I realized that life, my education, the different things that I had faced in life really brought me a special connection to family law. And I think that's because unlike many areas of law, family law, we are working directly with individuals and their families. So there's more of a connection with our clients than you might have in other areas of the law. For me personally, that was what drew me to family law. And 10 years later, here I am.
Wonderful. And in this COVID-19 environment, what are women facing if they are seeking to get a divorce and the courts may be closed?
It's such an unusual time for everyone, and information is not readily available. So many potential clients or existing clients are calling us concerned that the court is closed, and it is closed, except it is available especially for family law emergencies and other emergencies that might come up. But the family law emergencies are of the greatest impact directly on our families and the local community. So first and foremost, I would like women to know that the courts are open for them for emergency cases. And this might include emergency custody cases or what we're seeing, unfortunately, emergency protection from abuse orders. The court is available for emergencies with hearings and filings. For divorce itself, for the actual process of the divorce, although the courts are closed, they are accepting filings. And some of the cases are being heard by telephone, either by judges or by masters, depending on the county. We practice in 4 different counties, and each county has very different processes during the COVID-19, and it is subject to change very often. So we definitely recommend that if there's any question as to whether a matter could be heard or could be filed, to please check the website for the court, but also call a family law attorney, because we are all very willing and very eager to help people who are suffering during the COVID-19 crisis to make sure they know help is available through the courts.
And to follow up with that, what are some of the challenges like enforcement in this context for women with child custody, alimony, and child support issues? And could you please define those terms as well?
Absolutely. I'll start with support because the financial impact of COVID-19 is what is traditionally we're finding and anytime we have a conflict, the financial impact is usually what we feel first. And what's happening right now is that we can't really enforce support orders for two reasons. One is that there's limited court proceedings being heard, but also because many people have lost their jobs. And what's happening is although payors, so in a child support order, you have a payor who pays the support and a payee who receives the support. And many payors are losing their jobs and not able to get unemployment benefits yet. We're hearing clients tell us that it's been weeks and they still have not received their benefits. What happens, unfortunately, is that the child support, which will wage attach to the unemployment benefits, that child support cannot be wage attached, so our clients are not receiving support. Or if we represent the payor, our client is not able to pay support because unemployment benefits are not coming in. To be very frank with you, it is very likely that support, especially child support, will be the busiest part of our lives when we return to the courts, because we will have both enforcement proceedings, which is the court's effort to get the money from the payor. So that's the enforcement. But we're also going to have modification petitions. And what a modification petition is if a spouse has lost his or her job, then they're going to seek to reduce their child support. So we're definitely going to see a lot of modification petitions, which will have a very direct and a very immediate impact on women, on men and women, but particularly for this show, on women. Because what we're going to find is that the court will be busy. And so there's going to be a bit of a backlog in hearing these different types of proceedings. What we are recommending to our clients for child support, whether we represent the payor or payee, is to file what needs to be filed now so that they're in the queue of what's going to be available to us for court appearances. I'm very happy to report that many of the counties in which we practice are now using, or will be very soon, using telephone conferences to start to work on that queue. So essentially, don't delay. When it comes to the financial consequences, the sooner someone is able to address it, the better. Alimony there's two parts to alimony that I think will impact many women during COVID-19. And what alimony is support of a spouse. But there are two forms of alimony. One is specifically alimony, which is support after the divorce is final. So for instance, if a husband and wife divorce and wife is receiving alimony after the divorce, that is part of the divorce proceeding, and that is a final order of court, and that money is due to the spouse almost always without regard for modification. Alimony pendenti lite, however, it's called APL. That is support during the pendency of the divorce, and that is modifiable. So where COVID-19 is most likely to hit will be in the APL payment. Because APL is modifiable, there is a possibility that that APL will be reduced if the payor loses his or her job. So much like child support, we definitely want to make sure that if there are any problems with the receipt or the payment of APL, we take action as quickly as possible to preserve the right in the queue. Finally, with regard to the divorce proceedings themselves, there will be more of a backup with regard to the court and divorce. However, they are processing what they can process. Financially, though, they are impacts that are more immediate and we can take action. Moving to custody. Oh, I'm sorry.
Oh, please. I was just about to ask you that.
Okay. Moving to custody, I will say that it's a bit of a gray area. The actual law is that you must follow the custody order as they are presently written. It is an order of court, and someone cannot unilaterally decide not to follow the custody order. In practice, what we're finding is that some spouses are unilaterally deciding that the best interest of their children outweigh their need to follow the court order. And I want to be delicate here because everyone must follow the court order. It is an order of court. But the best interest of children, that's where our heart is. And so what parents are doing is withholding children in custody exchanges for a variety of reasons, most often because they believe the other parent is not either social distancing or works in a field that cannot allow them to social distance. It's a very difficult spot for parents to be in because there is a strong argument on both sides. But ultimately, what is critical for everyone watching to understand is that a court order is a court order. And when we return to court, we can expect that there will be contempt proceedings for withholding custody. What we most strongly recommend is that you work and dialogue with the other parent whenever possible, because both parents usually deep down have the best interests of their children at heart, and a good dialogue and trying to protect the children and keep them safe often results in what we call informal modifications of the custody order, meaning mom and dad both decide we are going to keep custody with mom because dad works in a field that isn't safe. We're going to do this temporarily. It will have no impact whatsoever on the long-term custody. And then my recommendation as an attorney is to make sure that that informal modification is in writing. It can be a text message, it can be an email, but we always want to make sure that any type of modification to a court order that's agreed is in writing.
Thank you for that comprehensive deep dive. I also wanted to ask some more detailed questions. What if one of the partners in a relationship hold the health insurance? What would happen in that event?
The partner who holds the health insurance must continue to hold the health insurance if there is a support order. So in our child support or APL orders, it will state whether or not one spouse is giving or spouse or partner is giving the health insurance to the other or to the children. I'll call that person the employee's spouse because more often than not, it's the spouse who has coverage through his or her employer. That spouse must continue to provide the insurance unless there's a change to the support order that removes the liability from them, the obligation from them. So many times we'll hear a spouse say to the other, I'm going to shut off your insurance. I can't afford it anymore. They really cannot do that. We can petition the court to make sure that the insurance is reinstated. We could potentially do that as an emergency, depending on the factual circumstances in that particular family. For instance, if there is someone with COVID-19 or someone with an underlying medical condition, it might rise to the level of an emergency filing. But it is important to know there is recourse. That's during COVID-19 and not during COVID-19. This is one area where we find a lot of abuse from one spouse to another, the constant threatening or sometimes even termination of the health insurance benefits.
You talk about recourse, and I wanted to bring the conversation to the issue of domestic violence. If a woman is fearing for her own safety or the safety of her children, what recourse does she have and what does it entail?
First and immediately, please contact the police. If you have been physically harmed, if there's the threat of physical harm, if your children have been physically harmed, please contact the police. They will assist you in taking the steps necessary to protect yourself, and you can still appeal to the court. Right now, although the courts are closed to the public, they are open for protection from abuse filings and the hearings to have the order entered. This is an absolute emergency. Mojdeh, you might know that the calls, domestic violence incident calls are up, but the filings are not. And what that's indicate, and when I say filings, I mean court filings. What that's indicating is that many women and people protecting their children are not aware that they can file for protection from abuse with the court. The incidents are happening, they're going up, and yet our filings are going down. So please know that you can absolutely appeal to the court for a protection from abuse order. I can explain what that is, if that would be helpful. Protection from abuse is a quasi-criminal order. It's a civil order that prevents a spouse from being able to physically abuse you or your children. It actually protects against the abuse of any intimate partner, family or intimate partner. In the event that you need protection from abuse, you will file a petition for protection from abuse, and you will plead the basic facts in your case so that the judge can make a decision whether to enter a temporary order. The temporary order will be what we call ex parte. Your spouse is not there, it's just you and the judge. And the judge will make a determination as to whether the facts in the case warrant a protection from abuse order being entered on a temporary basis until there is a formal hearing down the line. If a protection from abuse order is entered in your case, your spouse or intimate partner will be required to leave the house. He or she will not be able to return back to the house until there's a hearing and a judge makes a final determination. This provides some breathing room for you and for your spouse. It separates you physically during this difficult quarantine time, and it will also, the goal is to also prevent any further physical abuse. If, however, the abuser violates that protection from abuse order and either calls, texts, or shows up at the house, then it becomes a potential criminal matter, and enforcement of a protection from abuse order can give rise to criminal charges. It's a powerful tool. It's not always enough, I'm sorry to say, but it is a powerful tool, and we really want to make sure that everybody knows that help is available. And please contact the police first and a family law attorney to assist you if you have questions about that.
That's very valuable information and something that many women are not aware of during this COVID-19 time. I wanted to circle back to some of the financial issues. What if one spouse has control of the financial accounts in a relationship? What would they do then in a divorce situation right now?
I have to tell you that right now we are not very successful in having many financial matters heard. The reason for that is that the capacity of the court is limited, and although they're working very, very hard to keep matters moving forward, most of our divorce matters are on a potential prolonged hold. And I say potential because we're all optimistic we'll be back to court in early summer. But it could be prolonged. And so what we're working with our clients is, one, enhancing the communication between counsel. So if there are two attorneys in the case, we are working very hard to soothe the financial strain on the family by negotiating different types of, and I can go into some of these, but different types of financial settlements so that both parties who are already in a difficult position, often quarantined together, both parties will have some financial freedom. If there are not two attorneys on a case, and if spouses are negotiating together and they cannot because one spouse might be financially abusive, in a case like that, you could potentially have an emergency filing if it rises to the level that you are simply unable to support yourself or your children. So if all access to all money has been suspended and there is no food in the house and you can't buy basic supplies and needs, that could very well rise to an emergency level. What we would do in a case like that is we would file an emergency petition and ask for one of two things. One would be some type of financial support set aside for the spouse. I want to point out this would be different than APL. This would be more like taking money from an asset that will eventually be distributed to the spouse and giving it to her in advance. For instance, let's say that a house will be sold as part of the divorce, but you can't do that right now. And you know that you'll get $100,000 from the sale of the house. We might ask the court to issue an emergency giving you $5,000 right now against what you will be owed for that house in the end. The reason is that we just need to find some way to get cash flowing to you. And because support is not likely going to be heard as an emergency, that would be the best path we can take to try to get the court to hear it during this time. I just want to point out, though, that it really would have to rise to an actual emergency level. So if there's access to credit cards, if there's food in the house, but there's no extra spending money, that's not going to rise to an emergency level. We need to be able to establish that the basic living needs of children or a spouse are not being met. It's unusual right now.
And what about job loss? You mentioned emergency conditions. Would the job loss meet those standards of emergency?
It depends if it involves insurance. So if it involves insurance, I would argue that yes, depending on the factual circumstances of that particular family, it could very well rise to an emergency. I think that I I have found that many family law attorneys are being quite careful on what we file as an emergency, just with deference to the court and the struggle that they also have in making sure that they can keep everything moving forward. So, unless it's directly impacting life for the children and a spouse, we're probably not going to jump to an emergency filing because we need to be respectful of the court's time and we need to be respectful of people facing physical emergencies, such as protection from abuse, and people facing custody emergencies, such as the abduction of children. So, with that deference in mind, if someone loses a job and that job loss results in an absolute inability to support oneself, then yes, it could rise to an emergency level.
I'd like to switch topics, and I would be delighted if you could talk about the legal guide to family law in Pennsylvania, available online from the Women's Resource Center, which you helped to revise and update for 2020.
It was my pleasure to help revise it because I think it is the best resource available, both for women who are doing it themselves, going through divorce and custody without a lawyer, but also for women who have a lawyer. The book puts into normal language what I think the law often mystifies. So I can tell you, as a family law practitioner in 4 different counties, every single county is completely different than the other. And so even we practice heavily in each of those counties, we still have to check the local rules all of the time. And that's as practicing attorneys handling many, many cases. One of the key things I hear from consultations at the Women's Resource Center is that they know they can do it themselves. They just need to understand the law and the process, which is very difficult for everyone, including attorneys. What I love about the Women's Resource Center guide is that it breaks it down into the steps. It tells you precisely these are the different steps that you will go through in your process, and this is how you can make that happen. It's very empowering, especially for someone who knows that she can do it herself. She just needs a little guidance. That book provides that guidance. I think the book is a great resource for women who also have lawyers because it also translates sometimes what we say. Sometimes as lawyers, we forget that not everyone knows perhaps what a precipice is. We forget that. And you can turn to that book and see, this is what my lawyer is talking about. It just helps guide you in how you communicate with your lawyer as well, and also in what you can expect from your lawyer, as well as what you can expect from the court. I recommend that book to many of my clients and all of my consults. It's a fantastic guide. And thank you for publishing it.
Oh, thank you for your help and your expertise in updating the guide. I wanted to also alert our viewers that the guide offers a glossary of legal terms, a sample of expenses that you would encounter, as well as a list of resources, local resources and regional resources with regards to family law issues in Pennsylvania as appendices, in addition to full explanations of the process of divorce in Pennsylvania and its related issues. The legal guide can be obtained as a digital download from the website Women's Resource Center, which is www.womensresourcecenter.net. All you need to do is click on Get Help and then click on Family Law for the page to obtain a digital download for $10 of the Family Law Guide in Pennsylvania. Finally, I wanted to ask you, Jennifer, if you could talk about your longstanding service to the Women's Resource Center. You've been with us for over 10 years. And could you briefly elaborate on your current volunteer and affiliate roles with the Legal Night?
I'm very honored to be a volunteer at the Women's Resource Center. So I want to thank you for the opportunity because it's a different way to connect with women in our community, and I just appreciate it so much. I provide free consultations through the Women's Resource Center's Legal Night. I sometimes do the Women's Resource Center in Wayne. I meet with women in your actual facility. And at other times, once a month, we host the Women's Resource Center in my Blue Bell office for clients who might be in Bucks or Montgomery County. The consultations are a free half hour. We speak as quickly as we can to give you as much information as possible, and we cover any legal concerns that women are facing for their families. It's an amazing resource. I cannot stress enough how appreciative I am that you offer this and that I can be part of it, because the information that women receive in these consultations is often enough to really free them from a bad situation that they think they may be stuck in. I think what's beautiful about the Women's Resource Center and all of the different services that you provide is that you help women understand they're not stuck and that there are women out there willing and eager to help you and to help give you the new life that you're looking for. That's what we do with the legal consults. We help make your legal, I'll say, mysteries less mysterious and something that you can conquer, because it is absolutely true that knowledge is power. And any place that we can offer that knowledge, it's going to empower all of us. And the Women's Resource Center offers that in so many different ways. So I just want to thank you for that. And I hope your listeners can take advantage of the career and legal and other mental health and other counseling that's available for them there.
Thank you, Jennifer. I wanted to mention, in this current COVID-19 environment, we're offering the legal consults virtually. So Jennifer's offices would be communicating virtually by phone or video chat with the clients coming in for that 30-minute, $10 legal consult that we offer. And registration is through our website. Thank you so much, Jennifer, for sharing your knowledge, expertise, and experience with us today.
It was my pleasure. Thank you so much for having me on today.
The WRC is also grateful for having you as a longtime volunteer attorney to our nonprofit organization. For the viewers out there, thank you for watching Women Speak. I look forward to bringing you more in-depth conversations on women's issues. And for more information, please visit www.womensresourcecenter.net. Thank you and take care.